The gentleman from North Carolina is recognized.
Thank you, Madam Speaker. The distinguished gentleman from Georgia suggests that this bill is about whether or not we're preserving the right to jury trial in the Constitution. But I submit that's not really what's at stake. The question is whether you resolve a dispute through arbitration or you go to the court system. If you go to the court system, there are innumerable paths within the court system that lead to not having your case decided by a jury. In fact, only about 1 to 2% of cases end up proceeding to a determination by a jury. That means 99 or 98 out of 100 cases do not. They might be dismissed on a motion for summary judgment. They might be dismissed for failure to state a claim. There may be settlement processes that come to fruition during the course of a case. But it's almost never true. Think about that a case in court goes to a jury. So this notion that this bill, by eliminating the choice of arbitration, somehow preserves everybody's jury trial right magically is a false choice. And more to that point, the gentleman from Georgia and also the chairman in the inception noted that, noted that we've just had a bill signing of a bill that accepts from enforceable arbitration agreements the category of sexual assault, sexual harassment. The majority of Republicans supported that. The majority of Republicans will not support this bill because it represents the throwing out of the entire mechanism of arbitration, which has been, as I indicated, a feature of the legal landscape with great utility and utilized throughout the last 100 years almost, since 1925. And with that, Madam Speaker, I yield 3 minutes to the gentleman from Oregon, Mr. Bentz.
The gentleman is recognized.
Thank you to the gentleman from North Carolina. Madam Speaker, I move to recommit H.R. 963 and have my amendment that strikes the retroactivity provision of this bill included in the record. It is wrong, clearly not right, for Congress to step in and retroactively invalidate parts of millions of existing contracts. The parties to those contracts, in good faith, relied on those parts of their contracts when they struck their bargain. But if this bill becomes law, it will rewrite millions of existing contracts, which will lead to waves of new litigation. This litigation will place new costs on businesses, consumers, and employees who will be forced to pay more for lawyers, hundreds of dollars per hour, and may get stuck for years in long court battles instead of having available the solution of arbitration. Applying new laws retroactively undermines the rule of law and upends the certainty that parties are trying to create when they negotiate and enter into a contract. My motion would make this bill apply only to agreements entered into after this bill goes into effect. I offered this amendment at the markup in the Judiciary Committee, but the Democrats there rejected it. I offered this amendment to the Rules Committee, but the Democrats there chose not to make it an order. I offered this amendment for a third time here on the floor of this House because this matter is critically important. Retroactively voiding millions upon millions of existing contracts is truly bad policy. By making this bill apply only to future contracts, we can avoid the inherent unfairness of having Congress directly interfere in millions upon millions of existing agreements. I urge my colleagues to support my motion to recommit. Madam Speaker, if we adopt this motion to recommit, we will instruct the Committee on the Judiciary to consider again my amendments to H.R. 963 to ensure that the Democrats' attempt to eviscerate arbitration will not apply retroactively to the millions upon millions of contractual agreements already in place. I ask unanimous consent to insert the text of this amendment in the record immediately prior to the vote on the motion to recommit.
Without objection.
I yield back the balance of my time.